Hello, my listeners. This is Mubiru Musoke with another conversation on democratization of Africa, the case of Uganda in comparative perspective. Last week, I talked about the structure of human rights jurisprudence. Instead of continuing with the conversation on political, the philosophy of law, which I did in the first conversation, I think I've decided to switch gears and talk about corruption, because that seems to be one of the biggest problems we are facing at this time. And the structure of what I call the structure of the logic of jurisprudence of human rights is very, very important. One of the central pillars in this structure is the supremacy of the Constitution, which I pointed out. The supremacy of the Constitution is a very important principle in the process of democracy. The reason is that it prohibits a legislature from enacting a law that is inconsistent with the Constitution. And that is the best way to protect minority rights, because if a majority could pass any law that, for example, either repeals or amends or abolishes the Bill of Rights, then nobody would be secure. There is nothing in the U.S. Constitution, there is no article called the supremacy of the Constitution. This principle arose from the Chief Justice Marshall in 1802 interpreting the U.S. Constitution, and he did so by pointing out that the principle of separation of powers logically gives the three branches separate functions and powers. The executive exercises the executive powers, the legislature enacts laws, and the judiciary interprets the Constitution and all other laws. So the logical, that constitutes what I call the logical structure of the jurisprudence of human rights. And the central pillar of this structure is the supremacy of the Constitution. And this principle of the supremacy of the Constitution has been, adopted almost worldwide. We have it in Uganda, they have it in Kenya, they have it in South Africa. It is now a universal principle. But originally, it was never enacted as an article in the Constitution. It was the result of interpreting the structure of the Constitution. So today, I'm going to illustrate how this principle is relevant to Uganda, to fighting corruption in Uganda. Corruption in Uganda is partly caused by what I call the NRM regime culture. What do I mean by that? Every organizational structure is susceptible to corruption due to the nature and the existence of a regime culture, according to which it is administered and or conducts its affairs. This means that corruption caused by regime culture is predictable to the extent absence of effective internal institutional checks and balances of an organization result in the encouragement and or causation of corruption within the organizational structure. Translated in ordinary language, control of corruption in any system or organization directly varies with the degree of its democratization and the transparency within the organization. Direct accountability to the electorate is an essential factor in controlling corruption in any organization, or even the state for that matter, as we shall see with the examples from Uganda. Causation of corruption by regime culture, although universal, is not very well understood or appreciated by the students of politics and law. In the case of Uganda, the NRM regime culture was established by the political process through which the movement system came into existence and dominated the Ugandan political landscape unopposed. The original principles under which the movement system was organized, namely the broad-based government, which sounded very good, individual merit, which also sounded very good, and the suppression of all rival political organizations as long as the movement system was in force, inevitably, however, made the NRM organization, which succeeded to the movement system, a very pervasive and corrupt political organization throughout the country. Both the movement system and the NRM, which succeeded it, had no effective internal system or mechanism of checks and balances, which is the same thing as saying that there was no democracy under the movement system of government in Uganda. We narrate a few illustrations of the nature of the impact of NRM regime culture program in this conversation. Human Rights Watch, hereafter HRW, through its research in Uganda, published in October 2013, made an important and not surprising finding. In Uganda, the Human Rights Watch wrote, corruption is the way the regime survives. The current regime is in survival mode, and it depends on corruption, unquote, in order to function effectively or in order to survive. Human Rights Watch finding is corroborated by Justice George Kanyehamba. Kanyehamba has reached an identical conclusion as Human Rights Watch. He recently pointed out that he, meaning Museveni, and his government have totally failed to fight corruption. Several of his ministers and many more NRM party cadres and supporters are alleged to be thoroughly corrupt. President Museveni himself has publicly named many of them, but he continues relying on them for his prolongation in political office. Many Ugandans believe he is frightened of them. It is common knowledge amongst many of his ministers, party cadres, and supporters that he is so much sustained by the corrupt in office that it is near impossible for him to survive politically without them, unquote. So Kanyehamba adds that the crucial part of the explanation is this: most, if not all, the fundamental safeguards enshrined in the Constitution have been removed or stripped naked by the intolerant executive. In other words, there is no mechanism of checks and balances within the regime in Uganda. That's part of the explanation for the prevalence of corruption in Uganda. Kanyehamba was at one time an insider within NRM regime. We can therefore take his conclusion to be reliable and probably vindicated by his experience. Both Kanyehamba's opinion and Human Rights Watch finding based on their research in Uganda are compatible with the theoretical prediction of what to expect under a dominant and pervasive regime culture which, without effective internal checks and balances in the organization. Human Rights Watch's finding also explains most of the problems that have made fighting corruption in Uganda difficult for several reasons. First, the finding of Human Rights Watch explains why there is an insatiable incentive and a concerted effort on the part of the NRM top leaders, including the president himself, to actively interfere with the anti-corruption institutions which were originally established with the intention of combating corruption in the country. For a long time, for example, the leadership code, which was enacted in 2002, remained dysfunctional and not fully enforceable because the tribunal, which has the power to enforce the compliance with the leadership code, was not appointed and therefore did not exist for almost a decade. This meant that the IGG, the Inspector General of Government, decisions could not be fully enforced even where a clear violation of the code was found to exist. This glaring omission, viewed within the context of Kanyehamba's conclusion, was not the result of incompetence, but a deliberate political decision calculated to enable many top NRM leaders to escape the wrath of the law. This situation existed for almost a decade. During that period, the leadership code was nothing more than a toothless law slumbering in the statute books. It allowed the NRM leaders to violate corruption law with impunity. We must point out one thing. Uganda has enacted a lot of laws, anti-corruption laws. They are on the books. And Uganda has created many anti-corruption institutions. But at the same time, Uganda has more corruption than any other country we can imagine on the continent of Africa. So how do we explain the existence of anti-corruption institutions and laws and the prevalence of corruption at the same time? It's the absence of the checks and balances in the system. In other words, it is the absence of democracy that explains the situation. Second, in a situation similar to the failure to appoint a tribunal to enforce the leadership code, important IGG, Inspector General of Government personnel, essential to the functioning of the IGG as an institution as originally contemplated by the Parliament, the IGG lacked two important officials, that is, two deputy IGG officials, one of whom was supposed to be qualified to act as a judge. The failure to appoint these two IGG officials, which can hardly be explained as an oversight on part of the appointing authority, who is the president, led to the dismissal of corruption cases of high-ranking NRM officials by the courts on the ground that the IGG as a legal institution was not properly constituted and therefore lacked the legal capacity to prosecute the cases against the three cabinet ministers, for example, one of whom, Sam Kutesa, is closely related to the president. These are not coincidences. The case against the three ministers had to be dismissed, not for lack of evidence, but on the ground that the IGG institution was not properly constituted and therefore had no legal authority to investigate and litigate the cases for which the IGG had sufficient evidence to litigate or to prosecute in a corruption division of the High Court. From these examples and contradictions, internal regime culture can be both contradictory and astounding. In Kutesa's case, the constitutional issue to be resolved by the court was whether, when only the Inspector General of Government in an acting capacity is the only one lawfully appointed in the office and the other two deputies are not yet appointed, it is constitutional that the Inspector General of Government as an institution can prosecute or cause prosecution in respect of cases of corruption, abuse of authority, or of public office. The court, not surprisingly, answered the question in the negative. Quote, "We are not persuaded by the submission of the framers that the framers of the Constitution intended that the powers vested in the Inspectorate of Government as a composite entity were also vested in the Inspector General of Government, who at the same time is a member of the Inspectorate of Government to be exercised singularly and or independently of the Inspectorate of Government." The ultimate result, the court wrote, of that would be for the Inspector General of Government to override or at his whims the Inspectorate of Government as to the exercise of the powers vested into the Inspectorate of Government. That language I'm quoting may be confusing to some of you, but it will become clear as I go along. The court added that it is clear that to us that under the Constitution, the foundation of the powers of the Inspector General of Government is the existence of the Inspectorate of Government. The Inspector General of Government can only carry out the powers vested in that office as such only when the Inspectorate of Government is in place exercising its powers. The Inspector General of Government implements what the Inspectorate of Government has resolved upon. What the court is trying to say is that until all the officials, the essential officials of the Inspectorate of Government are appointed, they don't have power to prosecute corruption, even if they have the evidence. In plain language, the court was arguing that the case of corruption against the ministers, including Kutesa, the relative of the president, had to be dismissed because the IGG institution was not properly constituted. In their own words, the justices concluded that the Inspectorate of Government must be in existence when fully constituted, as provided for under Article 223 of the Constitution and Section 3.2 of the Inspectorate of Government Act. Therefore, the IGG had no power to wage war on corruption until the Inspectorate of Government was fully constituted. In other words, the accused had to go free. The regime culture, what I call regime culture of NRM, had taken its mangled logical course. And the ministers, the three ministers, were free, and even though the evidence was there that they had committed corruption crimes. To further complicate the problem of NRM regime culture, which was dictating these astoundingly contradictory results, the DPP has exactly the same powers to prosecute corruption cases. The question is why the IGG, fully aware of the legal incapacity of the IGG, nevertheless proceeded to prosecute the cases against Kutesa and two others when the DPP, Director of Public Prosecution, could have accomplished exactly the same task without the implications of the institutional infirmity arising directly from NRM regime culture. The corrupt logic of the regime culture could not allow a rational process of prejudicial to the top officials of the regime. Moreover, having been unsuccessfully prosecuted by the IGG, the three ministers could not be later prosecuted because of the constitutional principle that prohibits double jeopardy. I'm going to stop here for a few minutes, and I will be back to continue this conversation. Thank you very much.
okubuuka n'okudingisanga kye bayita okuyimba so si ttererezo kwenna bana abaali bangoba basajja batu babalekera saati nga zenna emakudde abakolagananga n'abalabe bange saabanenyabo ye yali endowooza yaabwe bajjukira eminagiro gye beesuuliranga nenzijukira n'ebibindi bye banfuuyiranga bwe bagamba nti tebantyamba nange betya nkomyewo bazanya n'engoma fayasi wadde amazima kuba mugakaawa ate okugasanguza ke kasanyo kange kayimba kammwe ababaka ba paalamenti ndibeetondera ndibeera mbeetaze mukimanyi bulungi nti ffe twabalonda okugenda mututuusiza ebizibu byaffe n'abamu mugawalayo mwali mponga byoya ne tubeera nga twakikola kubayamba abandi twabalonda lwanjogera zammwe ebyemwatusuubiza bwe muli bamutuuse neewuunya abamu okuva lwe twabalonda mwatufuula biyenje n'omwatufiisa ffe tubalinze mukomewo mu biyenje byammwe musukkanga ku 2 olwo obukongovule bube bweteefuteefu enkalufolo lwesirijja okubunoonya ensige nejjanziro biriteesa bibuke nolisanga n'obote nga komyewaafugesi nga bw'atayinza kudda nammwe temuddanga abantu banyiivu mwabadisapoyintinga kibajjera ku lwazi era zirese endagala bwe ndibeera nga nzaye mulikomba paalamenti yaffe okwefuula batuuse bugge embooge musule netubasindikangako mu paalamenti tiba mutuuka mutuyamba mwekkiriranyinga ekyakusindisa otulo mu paalamenti gwe tolikomawo nga kyotugamba kyeki nawe wataalina kyewateesa kyonna ebyekisanja ekirala matotawana n'abazinira.
Now we can continue with our discussion, our conversation on the impact of NRM regime culture on the war on corruption in Uganda. One of the most blatant interference with the anti-corruption institutions by politicians was the derailment of Faith Monda's appointment to serve a second and final term as IGG head in 2008. Faith Monda, was a tough lady. She had proved to be a very aggressive IGG leader. Such a reputation was not only dangerous, but also incompatible with the interests and the behavior of the corrupt politicians in NRM. Moreover, the reappointment of Monda coincided with the revelations of the Global Fund corruption scandals, in which 3 NRM ministers were accused of being involved in embezzling of $12 million of aid money from the Global Fund. And these facts were revealed by the Judicial Commission of Inquiry headed by Justice James Ogola. At the same time of her reappointment, the IGG had investigated and convicted the leader of the Conservative Party, Ken Ruchamuzi, MP, for failure to comply with the provisions of the Leadership Code, which required him to file his assets and liabilities in a public disclosure statement required for all public leaders. The purpose of the disclosure is, of course, to fight corruption. Political obstacles have prevented the realization of the original objectives of this leadership code. In fact, Human Rights Watch has written that on its face, the Leadership Code Act appears to set up a very strong two-pronged anti-corruption framework by requiring financial disclosures for public officials and establishing a leadership tribunal to enforce a code of conduct for political leaders. However, such a body has never been formed, rendering the leadership code unenforceable in practice and crippling the IGG's ability to ensure accurate declarations in financial disclosure statements. Monda ruled that Rujamuzi's conduct required him to forfeit his parliamentary seat for 5 years as a penalty for violating the leadership code. Although in 2010, the Supreme Court vindicated Rujamuzi, the political damage was already done and had serious consequences on the war on corruption. The ruling sent a chilling message to all members of parliament who dominated and controlled every aspect of the power of parliament as a legislative body, especially those of NRM. It is therefore not surprising that all MPs, especially those of the NRM, belonging to NRM, who constituted an overwhelming majority in parliament of about 77% of all the MPs, they conspired to withhold consent to Museveni's reappointment of Monda as IGG head because she was too tough. Monda's abortive reappointment as IGG was, however, a clear case of political interference with the anti-corruption institutions intended to weaken the IGG as an institution, primarily responsible for the enforcement of corruption laws. The independence and autonomy of the IGG was henceforth questionable. The NRM regime culture assumed supremacy over the constitution, and as a result, the ability of the IGG to fight corruption was accordingly diminished, if not seriously crippled. The rest is history. Clearly, the NRM regime culture dictated these political results. In order to explain the causation of this type of corruption, one has to go far below the surface of the legal and political theaters within which the regime culture operates. Political interference with the enforcement of the corruption laws in Uganda, unfortunately, due to the predominance of NRM regime culture, like all regime cultures all over the world, goes deep, goes all the way to the top of the organizational structure. Mukula's case is a good example. The case arose from the Global Fund scandal, which we just mentioned above. There was sufficient evidence of criminal conduct, especially as uncovered by the Judicial Commission of Inquiry to charge Mukula for embezzling money from the Global Fund, headed by Justice Ogola, to sustain the conviction on the charges. As a result, Mukula was found guilty by the trial court. Surprisingly, however, Mukula's two co-accused, Jim Mwezi and Kamugisha, prominent members of NRM, were set free by the court on the ground that they had no case to answer, which means, in layman's language, that there was not sufficient evidence to prove the charges against the two defendants, and therefore the court could not proceed with the case. Mukula was convicted by the magistrate's trial court and sentenced to 4 years in jail. An angry delegation from Mukula's constituency protesting his conviction met President Museveni at State House. In the meantime, Mukula appealed his conviction. The president, in a clear violation of the principle of separation of powers, openly alleged that Mukula, whose case was pending before the court, was innocent. In order to back up his conviction in Mukula's innocence, the president contributed $50,000, or the equivalent of 100 million shillings, to Mukula's legal defense fund, an amount equivalent to about 50% of the money Mukula was alleged to have embezzled from the Global Fund. After Museveni's donation to Mukula's legal fund, a judge of the High Court, Justice D.K. Wangutusi, presiding over the appellate court, dismissed the charges against Mukula. Mukula's appeal was based on 5 grounds, but we shall discuss only 2 grounds, which best illustrate the case of political interference in corruption cases. The first ground was that the case against Mukula should be dismissed because a minister of government, by the nature of his position in the government, is not an employee of the government, and therefore could not be charged with the crime of embezzlement, whose basic element is that the employee steals his employer's funds and appropriates those funds to his or her personal use without the authority of the employer. On the first ground, the judge ruled that, quote, ministers are not employees, and that to refer to the minister in the particulars of the charge of embezzlement as an employee was an error, he wrote. However, from what I have read and understood in the judgment of the lower court, the decision would have been the same. It is my view that the appellant was not prejudiced and there was no unfairness to him by simply referring to him as an employee. No miscarriage of justice is detected and that would warrant the overturning of the lower court's decision. In my view, the error complained of is not so deplorable as to presume it harmful enough to cause an overturn of the lower court's decision. For those reasons, the first ground must fail. Sounds fascinating, but you wait until we go through another quotation. Another ground for the appeal that was based on the accused denial was based on the accused denial that he received the money alleged to have been embezzled. In other words, he said he never received the money. Actually, the words he used, the flamboyant as always Mukula was, he never smelled the money. It was not a disputed fact that the First Lady's office had requested the money from the Minister of Health through the accused. The money was to be withdrawn from the Global Fund account. It was also not a disputed fact that the requisition papers had the accused's name requesting the requisition of money on behalf of the First Lady's office. The accused argued that he had passed over the request for the money to the senior minister, Jim Wes. The only reason why the requisition papers were drawn in the accused's name was because the original request from the First Lady was made in the accused's name. The accused, however, vehemently denied receiving the money. Nevertheless, there was evidence to show that the cash in the amount requested by the First Lady was requisitioned and handed over to the senior minister, Jim Wes. Documentation showed that the money was withdrawn and handed over to the appellant to pass it over to the First Lady's office. The appellate judge concluded that of all the money requisitioned, quote, 210 million shillings disappeared along the way, unquote, to the First Lady's office. Another important fact in this drama was the fact that the accused, who denied receiving the money, nevertheless refunded 210 million shillings to the Minister of Health after the allegations of embezzling. The money had started circulating. The First Lady also refunded the balance to the Minister of Health. So there is no doubt that money was requisitioned and was transferred to the First Lady's office. In view of these facts, the appellate judge wrote, quote, in the instant case, the appellant was alleged to have received 210 million shillings. The prosecution laid evidence that they tendered as proof and acknowledgement of the receipt of the money. The learned chief magistrate then, as I have said earlier, found that it is a fact in dispute that accused two, who is Mukula, received and signed for all the money. This without first giving the appellant a chance to explain or rebut the evidence given against him. In my view, the judge wrote, this was a serious breach of procedure in that it amounted to convicting the appellant unheard in asking him to come back for his defense with accountability. The court was actually saying to the appellant, you took the money, now show us how you used it. This, in my view, wrote the appellate judge, was asking the appellant to prove his innocence. It was in an error. The foregoing shows that although the learned chief magistrate seemed at the stage of no case to answer to have concluded that the appellant had received the money, she still dealt with the issue after the defense and at the time of writing her judgment. It follows that what seemed to have been an unfair proceeding received relief that, in my view, removed the injustice and had been received at the stage of no case to answer. In the premises, since no failure of justice was occasioned, this ground cannot serve to overturn the decision of the Chief Magistrate's Court. Ground 2, therefore, also fails. You may think that Mukula was not smiling when the judge made those pronouncements, but in fact he was. In the end, however, in a curious logic in legal reasoning, the appellate judge reached the conclusion that the prosecution had failed to prove the case against the accused because beyond reasonable doubt. Quote, the sum total is that after subjecting the evidence as a whole to that fresh and exhaustive scrutiny, it is my finding that the appellant's criticism of the trial magistrate's court that he did not properly scrutinize and evaluate the evidence adduced at the trial, and by implication that if it had done so, would have rejected the prosecution's prayers and accepted the appellant's instead, justified. For the above reasons, this court is of the view that the charge against the appellant was not proved with the degree of certainty required, and that he was on the evidence entitled to the benefit of doubt and to be acquitted. The appeal is therefore allowed, the conviction quashed, and the sentence set aside. It is so ordered, wrote the judge. Now, this is confusing. First of all, the judge, on two grounds, he says that he cannot reverse the decision of the trial court. But then later on, he says, oh, the case was anyway not proved beyond a reasonable doubt. So what is going on here? I think we have a judiciary that is infected with the corruption itself. The democratic process which controls corruption through the system of checks and balances by enforcing the separation of powers has been seriously damaged by the NRM regime culture. This has weakened the judiciary. NRM regime culture has affected the judiciary in two ways we need to look at. The quality of judicial work has declined due to appointment of unqualified NRM cadres to important judicial positions, and as a result, the independence of the judiciary has been seriously eroded. The two factors have inevitably led to poor and sometimes politicized judicial decisions. The problem of lack of checks and balances, politicization of the judiciary, and especially malicious politics, as we shall see below, are all illustrated by the Kampala City Act, KCCA, scandal, which escalated into the political battle between an elected mayor of Kampala City, Elias Lukwago, and an NRM stooge, the director of Kampala City Authority, Jennifer Mosisi. It is not surprising that the parliament that enacted the KCCA, Kampala Capital City Act, was dominated by NRM members, about 77% of the members of parliament, a factor which has aggravated the problem of fighting corruption. Parliament, in enacting KCCA, was acting not in the interests of Uganda as a whole, but as simply implementing the directives from the president's office. In fact, President Museveni had a corrupt ulterior motive which he did not hide in wanting to control Kampala city management. NRM regime has attempted several times to have its members to be elected mayor, but failed. As a result, Museveni saw the solution in enacting KCCA, Kampala Capital City Act, as a means of controlling and manipulating the management of the Kampala city authority. Museveni achieved his objective by creating the position of Executive Director of Kampala City Authority, appointed by the President. The position of the Director of Kampala City Authority was designed to usurp and nullify the substantive powers of the popularly elected Mayor of Kampala City. To complete the control mechanism, KCCA also created the position of Minister for Kampala City, in charge of Kampala Capital City. All these unnecessary, if not redundant, administrative layers are a corrupt way to usurp and abuse the power of the people by a centralized structure that conflicts with and contravenes the Constitution. The purpose of KCCA is spelled out clearly. It is to provide for the administration of Kampala City by the central government. The objective of KCCA is therefore to enable the central government to administer directly a local government political entity that would otherwise be self-governing under the Constitution of Uganda. The laws which apply to the districts which are decentralized under the Constitution also apply to Kampala City Authority. Therefore, one has to assume that Kampala City Authority, the act which provides for the administration of Kampala City, capital city, by the central government, violates the Constitution. Districts are not supposed to be administered by the President's office, and it's so Kampala too, being having a status of a district, should not be administered by the President's office. The principle of decentralization is articulated in Article 176 of the Constitution. It is an important component of democratization. Given the history of Uganda, where oppressive regimes were in the past free and determined to control the people at the lowest levels of government, decentralization was seen as a means of preventing the central government from making decisions for the people at the local level. The 1967 Constitution established a highly centralized political structure which mistakenly equated national unity with the centralized national government. The movement system established in 1986 was even worse because the resistance council structures and later on the local councils formed an administrative structure which was commandeered by the local government ministry of the central government from the top to the lowest level of local government at the bottom. Decentralization under 1995 Constitution was consciously designed to break down and prevent the reintroduction of the two centralized systems established in 1967 Constitution and the movement system in 1986. Decentralization was therefore a weapon to dispel central government from local affairs and allow the people to exercise self-determination at the lowest level possible. Decentralization under 1995 Constitution was based on the district as the basic unit of local government. Under Article 276, it provides that the system of local government shall, quote, ensure that functions, powers, and responsibilities are devolved and transferred from the government to the local government units, and decentralization shall be a principle applying to all levels of local government, and in particular from higher to lower local government units, to ensure people's participation and democratic control of decision-making, unquote. So decentralization is therefore an important component of democratization of local government and self-determination of the people. One of the national objectives and directive principles of state policy in the 1995 Constitution deals with the democratic principles. One of these principles states that, quote, the state shall be guided by the principle of decentralization and the devolution of governmental functions and powers to the people at the appropriate levels where they can best manage and direct their own affairs. This national objective and directive principle clearly prohibits the enactment of KCCA, the Kampala Capital City Act. The purpose of decentralization is to democratize the system by devolving power to the people in their local areas. Decentralization and democratization are therefore intended to empower the people and not to usurp their power or authority by the central government. That's why Article 1 of the Constitution vests sovereignty in the people. By virtue of their sovereignty, all power belongs to the people, and all authority in the state emanates from the people of Uganda, and the people shall be governed through their will and consent. In order to attain these political objectives, the people shall express their will and consent on who shall govern them. And I'm quoting here the Constitution, who shall govern them and how they should be governed through regular, free, and fair elections of their representatives. The creation of the executive director of the authority, Kampala City Authority, appointed by the President, is therefore unconstitutional and incompatible with the office of the mayor of Kampala, who is directly elected by the people of Kampala City. In order to ensure that the sovereignty of the people will be protected by the Constitution and the authority of the people is not abused by corrupt leaders who can usurp the power of the people by enacting laws such as KCCA. The Constitution is declared by the supreme law of Uganda. The Constitution, quote, shall have binding force on all authorities and persons throughout Uganda, unquote. If any law, quote, or any custom is inconsistent with any of the provisions of this Constitution, the Constitution shall prevail, and that other law or custom shall, to the extent of the inconsistency, be void, unquote. These constitutional provisions were designed to prevent corrupt leaders from abusing their office. This, however, is exactly what KCCA does. The executive director is appointed by the president on the advice of the Civil Public Service Commission. The executive director is supposed to be a person of high moral character and proven integrity, qualified to be a permanent secretary in any government ministry. The executive director is the head of the public service of the authority and head of the administration of the authority. The executive director is the accounting officer of the authority, responsible for the management of public funds, and advises the mayor on government policy, oversees the delivery of services to the population of the capital city, and other things. One would therefore assume that the remuneration of the executive director would be determined by the rules of the civil service. However, Section 77 of KCCA does not mention the executive director among the members of the authority whose remuneration is determined by the minister in consultation with the Minister of Finance and Public Service. The basic salary of the current executive director is 36 million shillings a month, which is equivalent to $14,400 a month. This is an outrageous amount which cannot be justified both under the civil service rules and the per capita income of Ugandans. The salary of the executive director was determined under corrupt conditions, especially as the office of the executive director is equivalent to that of the permanent secretary of a ministry. I don't think the permanent secretaries earn $14,400 a month. I don't think so. The civil service rules would not allow that. But the executive director of Kampala City Authority does. This is a clear case, therefore, of corruption. Only the Lord Mayor and the Deputy Lord Mayor and the councillors are mentioned under Section 77 of the KCCA. The omission of the executive director is therefore deliberate. It was a corrupt. It has a corrupt motive. We are told by a member. We were told by a member of Kampala City, Mr. Sewanyana, recently on this radio, that the executive director determined the amount of her own salary by herself. This is clearly a case of corruption. Section 49, dealing with the financial provisions of the authority, violates the Constitution. Section 49, subsection 2, provides that, quote, the authority shall always accord preferential treatment to the national priority program areas in its budget outlays. This is a local government supposedly to make a preference in its budget for the national priority. This provision is inconsistent with the principle of decentralization on which the administration of Uganda is founded in the Constitution. Section 25 of KCCA gives power to the president to appoint persons to hold or act, quote, in any office in the service of this Kampala City of the rank of head of department or above, unquote. The functions of the Lord Mayor are very limited. They are limited to being political head, whatever that means, of the city, to preside over all the meetings of the authority, which means simply directing, listening to points of order and so on, to host foreign and local dignitaries, to head the authority in developing strategies and programs for the development of the city, and to monitor the administration of the capital city and provide guidance to the division administrations. Those are the functions of the mayor. Definitely, the executive director has usurped all the substantive powers, and the mayor has been given just the ceremonial powers. These largely ceremonial. The corrupt objective of KCCA was therefore to render the Lord Mayor administratively irrelevant and redundant. It is therefore ironical that the accusation against the Lord Mayor allege failure to exercise substantive powers in the administration of the capital city. I will stop here for a few minutes. We are now in the second hour, and I'll be back and conclude this conversation. Thank you. Okay, I'm back with the final second part of this conversation. The Kampala City scandal is important because it gives us a new perspective of the corruption that is going on in Uganda. Most people think corruption is the exchange of money, but in this particular case, it is largely the exchange of power rather than just money. Of course, the exchange of money also is involved, but first of all, it is the usurpation of power that is the most important aspect of corruption. So we will see. I'll give you a few details for so that people can understand this particular Kampala City scandal. A lot of people, I don't think, have followed it closely to understand it. The Kampala City scandal and the process used to impeach the Lord Mayor of Kampala exposed the extent of the corruption caused by NRM regime culture. The incompetence and corruption within the judiciary were displayed by the scandal for us all to see. A judge who was appointed to investigate the accusations against the mayor turned out to be a partisan NRM cadre whose only purpose was to execute orders from the president's office rather than to adjudicate fairly an administrative process. For example, given the functions of the Lord Mayor as laid out in the KCCA, the accusations against the Lord Mayor are ridiculous. Let us look at some of the details of the allegations against the Lord Mayor. A tribunal consisting of the Honorable Lady Justice Catherine Bamugemeire and Mrs. Joska Ochaya Lakidi and Mr. Alfred Okello Oriem, those are the three who were appointed by the minister to investigate the allegations against the Lord Mayor. The objective was to impeach and remove the Lord Mayor from office. Mr. Alfred Okello Oriem is a member of NRM and a member of the Museveni's cabinet. I don't expect him to be impartial. That would be surprising. Those facts should disqualify him, being an NRM member and a member of the cabinet, should disqualify him from sitting on the tribunal whose function is to determine the validity of the allegations against the Lord Mayor of Kampala, an outstanding leader of the opposition. Concerning the allegations of abuse of office, the tribunal concluded that the Lord Mayor, in writing a letter, incited the public against paying taxes. What we know about the mayor's statement in the letter is that it was a statement within his personal freedom to comment on public affairs in the city. He advised the residents of the city not to pay taxes, which the city cannot account for. Therefore, the mayor was warning the residents, and properly doing so, of the city against corruption. The tribunal, however, distorted the facts and concluded that the mayor, in warning the residents of the city to fight corruption, he did so in abuse of his office. Can you imagine that? Hence, the tribunal ruled a prima facie case was made out in respect of this allegation. Another allegation was that there was evidence on record indicating that the Lord Mayor, without approval or election by the authority, unilaterally appointed, recalled, and replaced representatives to Makerere University and the Mulago Nursing School. This, according to the tribunal, was unlawful, was illegal, and an abuse of his office. For that reason, a prima facie case was made out against the Lord Mayor in respect of this allegation. Regarding the failure to convene the petitioned meetings according to the provisions of the schedules in the KCCA, the tribunal concluded that there were several occasions when more than one-third of the KCCA's 34 councillors petitioned the Lord Mayor to convene special meetings to discuss specific agenda items. On many occasions, the Lord Mayor refused or failed to convene the petitioned meetings. In such instances, the Lord Mayor either changed the agenda items unilaterally without assigning any reason, or he based his refusal to convene meetings upon frivolous reasons, as the evidence of the record they claim shows. By so doing, the Lord Mayor acted unlawfully, acted illegally, and in abuse of his office. Consequently, the tribunal was convinced that a prima facie case was made out against the Lord Mayor in respect of the allegation. The tribunal found also that the Lord Mayor did not assign any importance to the work of the committees or the tabling of and adopting of their reports. The tribunal found that the Lord Mayor failed to accord importance to the functions of the standing committees and to cause them to be reconstituted after they expired. The tribunal concluded that the incompetence on part of the mayor was the only plausible explanation for that failure. Therefore, the tribunal determined a prima facie case against the Lord Mayor existed on the two allegations of failure to record importance of the standing committees and failure to reconstitute them upon their expiry. It was clear to the tribunal also that the respondent, who is the mayor, did not accord to the signing of the minutes the importance the law accords to that item in the schedule with KCCA. The tribunal defined incompetence as, quote, routine failure to perform a duty or function expected of a person possessed of skills to perform those functions. I would differ for their definition because according to dictionary definition of incompetence, it is the inability to perform the function legally assigned to you. That's what defines incompetence. Accordingly, a prima facie case was made out against the Lord Mayor in respect of this allegation about the willful misuse of information focused on the mayor by virtue of his office, the misinformation of the public, and propagate lies against the officers of the authority and the tribunal. They found the accusation well-founded. Eventually the tribunal determined that the Auditor General's ultimate position on this issue was contrary to the respondents' ill-conceived, improper and alarmist treatment of the management of the affairs of the city. The tribunal considers that it was irresponsible for the person of the Lord Mayor to disseminate contents of the management letter beyond the environs of the authority. Indeed, the tribunal construes the manner in which the Lord Mayor handles the management letter as misconduct. Now, I don't know whether these people have read the Freedom of Information Act. Even if somebody can file a request to get this information, and you can have it. And then the mayor is being alleged to have acted illegally just to disseminate the same information which the citizens are entitled to. That's ridiculous. While the advice of the technical staff was not necessarily binding on the Lord Mayor, the tribunal concluded that the Lord Mayor had a duty to implement ministerial directives. So the tribunal faulted the Lord Mayor's failure or refusal to implement ministerial directives and determined it was misconduct on his part. Consequently, a prima facie case was made out against the Lord Mayor in respect of this allegation. In conclusion, the tribunal found that the three grounds of abuse of office, incompetence, and misconduct or misbehavior were proved, and therefore a prima facie case for the removal of the mayor from office was, according to them, established. We started this conversation by pointing out that KCCA violates the principles of decentralization and sovereignty of the people. There is therefore no constitutional duty on part of the Lord Mayor to conform to ministerial directives issued from the President's office. Local governments in Uganda are based on the right of the people to govern themselves and enjoy self-determination. This the tribunal headed by a judge, whom I assume is a lawyer, and for that matter, learned and educated, could not understand these two principles which govern our Constitution. In fact, it is ironical that the executive director of Kampala City can accuse the Lord Mayor of being incompetent. Kampala City has been, affected by 4 fires in Owino Market since 2009. 2 of them happened during this year, 2013. Kampala Metropolitan Police has produced no report since 2009 regarding the causes of these fires. The responsibility falls directly under the functions of the executive director of the authority. It is very clear that the fires are the malicious acts of corrupt individuals in Kampala City, which has these acts have destroyed the welfare of people, the poor people, the merchandise of these poor guys who sell used clothes. The fire has destroyed everything they owned in their businesses, and since 2009, the Kampala Metropolitan Police has not issued a report about the causes of these fires. And you call the mayor incompetent and the director of executive director of Kampala City not incompetent? The police not incompetent? Where are they? Why can't they tell us what is causing these fires, and who is responsible, who has been punished? What is the police? The police are more interested in surrounding the Lord Mayor's house and than in investigating criminal activities. So, it is clear. It is very, very clear that the fires are the malicious acts of corrupt individuals within the city, and these people are winking at them. One of the biggest problems adversely affecting the administration of the city of Kampala is corruption. That's what I'm trying to drive at. That's why I'm going through all these details. And corruption is very pervasive. And let us not define corruption as the exchange of money, being paid a bribe. Why aren't these policemen not investigating these fires? That's corruption. They know that it is a criminal offense. They probably know who starts these fires, but it is not in their interest to investigate them and punish the people who cause these fires, which ends up destroying the life of these poor people selling used clothes like merchandise. So, in the absence of checks and which contributes to the failure of to effectively fight corruption, is checks and balances, and which right now, by removing the mayor, they are trying to remove those checks and balance administration of But anyway, I was trying to make a point that it's only democracy that really controls corruption. And the fact that we have so much corruption in Uganda is an index showing that there is no democracy in Uganda. There are no checks and balances. It's a very simple proposition. Now, the government, Museveni included, especially, is the one engineering all these scandals. He wants to remove the mayor, seen as an obstacle. Okay, the check on his activities and illegal activities and corruption. Yes, caller, go ahead and.
Yes, Mr. Mubiru, can you hear me now?
Yes, I can hear you, sir.
Yes, thank you. My name is Sanako, host of Gwanga Mj, and I thank you very much for the program enlightening us about the laws in Uganda. My question specifically deals on forcefully getting the government out of power according to what has been happening, according to the way the government has been abrogating the constitution. Case in point, what we have seen, what's going on in Uganda. I mean, as far as the mayor is concerned, Lord Mayor, the court had ruled that Mr. Mayor, I mean, it's to the mayor and the government had no right to proceed to impeach the Lord Mayor. Can you go back and tell us more in detail the reason? Because the government gives the reason that the ruling or the court had issued the stay of the impeachment after the fact, and that's what the Attorney General is telling us. For us who do not understand the implication of the law, can you explain us, the Attorney General, does he have the right, or the government has the right to ask the impeachment not to proceed, or the impeachment to proceed after the fact? Is there any way that you can enlighten us on this? And secondly, based on your answer you're going to give us, do we have the right to pick up arms and fight the government accordingly to the Constitution of Uganda? Give us that right. Do we have any legal basis in case any Ugandan decide to pick up arms and fight the government because of the way the government has abrogated the Constitution? Thank you, Mr. Mubiru, and I'll hang up and listen.
Oh, thank you very much for those two questions. First of all, regarding the Attorney General whom you mentioned, Attorney General Nyombi has either the notoriety or the reputation, depending on how you view him, of failing to understand the law, or if he does understand the law, of properly interpreting it and making sure that it is executed. For example, in a recent advice to the Minister for Kampala, the Attorney General came up with a very ridiculous argument that because the judgment of the court, the injunction, had not been served before the council made the decision, therefore the judge's injunction had no effect or was null and void because the council had already made the decision. It astounds me that a lawyer, even a first year law student, would not reach that conclusion, because the courts they can nullify even a meeting that took place 2 months ago. They can declare it null and void because it failed to comply with the rules, or the decision was not properly made, or violated certain principles. So this is the type of legal advice the Attorney General is giving out. Before I forget, let me also add this comment in addition to what the question was. The absence of democracy and the absence of accountability to the electorate leads to all incompetent people being either appointed or occupying certain high-level positions. The result is that the system suffers. What do I mean by this? Corruption affects the quality of the people who are either appointed or who perform. For example, the Attorney General is the best example. It's himself, a man who does not understand what the law is the man who is advising the government about what the law, means and how it should be implemented and executed. What I'm trying to say is simple. The absence of accountability of to the electorate by a democratic process is the source of appointing incompetent people or unqualified people, and that happens in all corrupt systems. All corrupt systems tend to be occupied by incompetent people because of the manner in which they are appointed and the way they have access to power. So that is one way of actually clarifying my point. We cannot, there is no advice I can tell you how we can go back and undo what was done by the tribunal. The best that can be said about this situation is to look forward and to fight these people, because now it has ceased. The process has ceased to be just a legal process. It's now a political process, and therefore I think political weapons should be pulled out and used to fight this system, this situation, the way, where the stage at which we are. The battle now is more political than legal. I don't know whether that answers your question or not. Now, the second part of the question was use of arms in fighting a revolution. Yes, you see, I've quoted the Constitution of Uganda many times, emphasizing those provisions. One, that the Constitution is the supreme law, and therefore any other law inconsistent with it is void. Like the Kampala City Act, in my opinion, it is void because it is inconsistent with the principles laid down in the Constitution. And two, the sovereignty of the people. Now, when you deny people their sovereignty, sovereignty means the right for people to make decisions affecting their lives. That's what this government is trying to do. For example, the mayor was elected by the people. And what is happening is that they are trying to nullify the election of the the vote of the people for the mayor, and they are trying to use stooges in the legal system and stooges in the council to try to undo what the people did when they went to elect the mayor. So when all that fails, I think the person who asked the question, the caller, was wondering what next. Of course, what next is to fight the regime, and we shall fight using all available means to remove the regime, because we don't have a choice. I mean, we can forget and go to sleep and the people suffer, or we can say enough is enough, we are not going to take it, and go ahead and fight the regime. And the Constitution, by the way, which was enacted by the NRM people, says that it is the right of the people to defend the Constitution and to use all means to defend that Constitution. And if anybody tries to overthrow the Constitution, you can use any means to fight that person. In this particular case, who is overthrowing the Constitution? It is the President. It is the President who is enacting these illegal acts, the Kampala City Act, who is trying to overthrow a man who was elected by the people, who is trying to abuse his power by saying that the sovereignty of the people as provided in the Constitution has no effect and should not be recognized. So, in that respect, I would say clearly we shall use all means possible to fight. We have a right, a human right, to defend our interests, and we have a right to self-determination and governance, to govern ourselves. So I want to encourage anybody who is ready and willing to fight this regime and bring an end to its violation of the Constitution. That's the only way to go. So, thank you, caller. I hope I've tried to answer your question. What I'm trying to say in conclusion is that because the second hour is coming to an end, enforcement of corruption laws in Uganda has many other obstacles to navigate besides the regime culture, what I call regime culture. Regime culture, I mean that the internal system or principles of a regime that it acts according to its internal principles of NRM. Those of you who have read the NRM Constitution understand what I'm trying to say. For example, Article 6 of the NRM Constitution says that the NRM organization is a multi-ideological political organization. I was astounded. I don't know what that means. A multi-ideological organization, political organization. It's like saying that you are going to create a religion that has the principles of Hinduism, of Christianity, of Islam, and all other religions, and say that it will give you a straight, passage to heaven. You know, when the scriptures themselves are conflicting, they cannot lead to the same ultimate goal. So that's what NRM regime culture. What I mean by that, it has no rational political philosophy, and without a political philosophy, you end up with the corruption as the guiding star, the guiding principle to achieve anything. So they don't be surprised by the extent of the corruption within Uganda and within NRM, because it is inherent in the structure itself, how the system is organized. Prosecutors are often, in Uganda, for example, are targets of the people they investigate. This is understandable because corruption in Uganda has mutated into organized crime. By mutation, I'm using that word, mutation, it is a biological term. It's a changeover from one phenomenon to another. Corruption, the existence of corruption once it takes a root in a society, it transforms itself into organized crime. This is a logical conclusion. I mean, it simply happens when there is so much corruption and nobody is punished and you can't control it. It becomes part of organized crime. And today, we don't be surprised. These fires we are talking about in Kampala, they are organized crime. And why aren't the police responding and investigating them? Because the police itself is part of this organized crime. Anyway, these conditions make corruption a prosecutor's job one of the most hazardous professional jobs. For example, the Human Rights Watch report published in October about Uganda revealed that a prosecutor's dogs were killed, and then someone called the prosecutor about it. The caller threateningly inquired from the prosecutor how his dogs, which had already been killed, were doing. The prosecutor's office is, however, an important link in the administration of criminal law. When the prosecutor's role is compromised by corruption, the objective of controlling corruption through the democratic mechanism of checks and balances becomes practically impossible. So it is also important to realize that an element of social class is involved in the process of combating corruption in Uganda. We have analyzed the case of Mukula, in which the president's blatant interference changed or influenced the result of the judicial process. This means, as the statistics on the prosecution of corruption clearly show, that the most powerful members of the society are not prosecuted. On the occasions they are prosecuted, they are not convicted. If they are convicted, they are not seriously punished. In the Global Fund scandal, for example, the four people who were convicted and punished were low-ranking officials. Mukula, who was convicted by the chief magistrate, had his conviction reversed by the High Court. Jim Muhwezi and Kamugisha were discharged by the court on a no-case-to-answer decision. Kavoyo, who pleaded guilty, was fined and probably used the money she embezzled to pay the fine. So the DPP and the CID, who were specifically requested to further the investigate, they were asked by the Commission of Inquiry to investigate these cases where there was evidence of corruption, had been discovered by the Judicial Commission of Inquiry. They headed by did not respond to the Commission's request to investigate. That is, the DPP and the CID were specifically asked by the Judicial Commission of Inquiry to investigate certain people. They did not. So you can see that why I'm saying corruption in Uganda has become an organized crime system. It is therefore not surprising that many commissions of inquiry which probe the junk helicopters, the police, the Department of Wildlife in the Ministry of Tourism, and many others did not lead to prosecutions. In the Chogam, scandal. The Vice President, Gilbert Bukenya, was charged, but the case was dismissed on a technicality. The cases against the three ministers involved in Chogam scandal, Sam Kutesa, John Sasira, and Rukutana, were discharged on the technical ground that the prosecuting institution, that the IGG, was not properly constituted and therefore had no authority to prosecute the accused. No person has ever been prosecuted for creating ghost employees in the police department and the UPDF. In the Prime Minister's scandal, where officials in the Bank of Uganda were implicated, only one, a low-ranking accountant, has been convicted and sent to jail. So the permanent secretary, who is the accounting officer of the ministry, that is the Prime Minister's office, was implicated in many of the transactions. And he was simply transferred from the Prime Minister's office to the Ministry of Gender. This is, I'm talking about the Bigirimana. So you can see the problem of our corruption in Uganda is very, very serious. And I must appeal to the donors, the people who give us aid. The money given to Uganda as aid is wasted when it clearly finds its way into the pockets of these gangsters. Because unless there is assurance that the aid given to Uganda will be properly used, there is no point in giving Uganda aid because it will not be used in the proper way it is supposed to be used because of corruption. So that is the case for regime change. You cannot really solve the problems in Uganda or the corruption in Uganda without a regime change. Regime change is absolutely necessary, and as one caller was pointing out, the people have to make sure that they get back their sovereignty from the government. Right now, sovereignty of the people in the Constitution is an empty phrase, because sociologically the people are not sovereign. The government is sovereign, and the government is corrupt. So until that problem is resolved, we shall be in very, very serious trouble. And I call upon people to get determined, to get serious, and to make sure that they contribute to the removal of the regime in Uganda by whatever means necessary. Well, as they said, those who prevent people from freely using democracy to change the regime, they invite the violence to be used to remove the regime in Uganda. So that concludes our conversation for today, which centered on corruption. But I want people to remember one thing, that the pillar on which the democratic system stands is the principles supremacy of the Constitution, and the logical structure of human rights jurisprudence depends on the supremacy of the Constitution, in order to make sure that laws that violate the Constitution are nullified and rendered void. And until then, please take care of yourself. Thank you, and goodbye.
You are listening to Voice of Uganda Radio, the mouthpiece of all Ugandans, wherever they may be, to voice their problems without fear of any retribution. The Voice of Uganda Radio works in sync with FADU, the Federalist Alliance of Democracy and Development in Uganda.